You have a point? Welcome. Welcome to everybody on this beautiful summer evening. I'm calling to order the City Council Executive Committee meeting. Today is Thursday, September 25th, 2025. Excused from the meeting tonight is Sarah Martinez, Roger Gomez, and Joe Latino. First up, we have a presentation, a collaboration under the Urban Renewal Law, Corey Y. Hoffman of Hoffman and Parker and Wilson and Carberry PC. Come on down. Wherever you want. There's plenty of room. Just hit your microphone when you get there. And thank you for coming tonight.
Absolutely. Well, good evening. My name is Corey Hoffman. I am with the law firm of Hoffman, Parker, Wilson, and Carberry. I'm here tonight to provide a presentation collaboration under the Urban Renewal Law. And I guess before I get started, I thought I'd introduce myself, tell you a little bit about me, and frankly, what my biases are. I believe in urban renewal. I think it is a valuable tool in the state of Colorado. My law practice is representing local governments. So by way of example, I'm the city attorney in North Glen, the city attorney up in Blackhawk. I represent a whole host of urban renewal authorities, including the ones in Arvada, Wheat Ridge, the one in Canyon City, and several others. So I want you to know when we start that I have a pro-government and pro-urban renewal bias, and you will get that from me as I go through my slides. If I can go through my slides. Okay, perfect. So what I hope to accomplish tonight is to discuss urban renewal in general, not any particular projects in the city, but really to focus on what I believe to be the interplay between the city and the Urban Renewal Authority, and really the urban renewal functions of the Urban Renewal Authority and the policy making function of the city. And I'm really going to focus on what I believe are the respective roles of the bodies and the fact that, frankly, urban renewal, in my view, can't work effectively without collaboration between the two bodies. And so what I hope to accomplish again is to address the respective roles of the two bodies and to discuss best practices in implementing urban renewal. And for what it's worth, this is a presentation that I do fairly frequently, and I typically do it for a combined audience of both a city council or board of trustees and the Urban Renewal Authority. I'm doing a variation on this very same presentation in December in Greeley, in February in Arvada. It's a fairly common presentation in the sense that I think as urban renewal, as the tool is gaining momentum again, following what I would call a significant pause after 2016, to make sure that everyone understands what their roles are and hopefully that the tool is utilized in an appropriate way. Next slide, please. So urban renewal at the end of the day is still about blight elimination. Urban renewal is not an economic redevelopment tool. Having said that, good blight elimination will absolutely result in economic development and redevelopment. But first and foremost, the tool is to eliminate blight. And so on the next two slides, I have all of the factors of blight that a city council ultimately considers in determining whether an area is blighted. And of the 11 factors, the city would need to find typically 4, unless it is done with the consent of a property owner, in which case you only need to find 1. And these are all factors: slum, deteriorating structures, inadequate street layout, faulty lot layout. I think many people think of a place like downtown Detroit or downtown Chicago or something like that when they think of blight elimination. But really, and next slide, please. If you look at the conditions of blight, it is, in my view, the type of conditions of property that for whatever reason make it either infeasible or in some cases impossible to redevelop because of certain conditions. And the type of conditions can be any of those factors of blight. It can be, for example, if you have an environmentally contaminated property, the cost of cleanup may make it so that if you have no money left to redevelop property. It may be that aging infrastructure has made redevelopment, if not impossible, infeasible. And so you look at the various factors of blight, and really what they are is a basis to look at property and understand whether it meets the statutory criteria, and if so, it is up to council to determine if it meets those statutory criteria, and then whether or not to adopt an urban renewal plan. It's a 2-part process. First is to determine if the blight is there, and then to determine if urban renewal is ultimately a good idea. And that is the policy determination of the city council. Next slide. So what are the roles? The city council is the policymaker, and I can't emphasize that enough. All of the urban renewal plans in the city of Pueblo, all urban renewal plans in the state of Colorado have been adopted by the governing body of the municipality. It is the goal or the job of you all as the city council to adopt the policy. You establish the boundaries for the urban renewal project area, you approve urban renewal plans, and in unusual cases, if absolutely necessary, you can authorize the use of the power of eminent domain. Next slide, please. By contrast, the job of the Urban Renewal Authority is to carry out the powers, to administer the plans and implement the plans that you as council have approved. And ultimately, that job is a job that is going to evolve over time. And you look at Pueblo's urban renewal plans. They are what I would call template or framework urban renewal plans. Very common, because it is a plan that actually lives forever. Urban renewal plans do not have a clock on them. What has a clock on it is the collection of TIF, the collection of tax increment. But the plan itself can last forever. There is no blight is automatically cured. And so at the time an urban renewal plan is approved, part of the approval process is it going through the planning commission to determine if it conforms to the comp plan. But over time, the city may amend its comp plan. And so that too is a living, breathing document. And so when I talk about collaboration between the city council and the board of the Urban Renewal Authority, it's important to understand that because it is the council's policy document, and policy may evolve over time, that the collaboration between the Urban Renewal Authority and the city council isn't just at the inception of a plan. It should be as the plan evolves over time. Next slide, please. Okay. So here are the representative powers of an urban renewal authority. And make no mistake, an urban renewal authority, once created, is a separate body. It has the separate authority to sue and be sued, to undertake the urban renewal projects that are approved by the city council, to do public infrastructure. There are some urban renewal authorities that their primary function is to utilize TIF to actually just build sort of the surrounding infrastructure so that then when redevelopment occurs, the infrastructure, say in the streets, is already there. That is one common way that urban renewal and the urban renewal function can be done. You are also arranging with the municipality for planning, replanning, zoning, rezoning. As part of the implementation of an urban renewal plan area, oftentimes the urban renewal authority is sort of championing through the city processes what is necessary to implement the council's plan. And ultimately, urban renewal authorities, and we'll talk about this in a little more detail in a couple minutes, become the subject matter experts. And so they may identify areas that they believe are appropriate for urban renewal and bring them to you. So in other words, put plans together, put condition surveys together, but ultimately for your consideration and approval. And there's no right way to do this, but urban renewal authorities are often the ones that create the initial condition survey and plan areas based on their expertise, bring them to council. City councils may say to an urban renewal authority or do independently say, can you look at this part of the city? We think this part of the city may qualify. Another common way that urban renewal is implemented is for a developer to initiate urban renewal, and it can be in a much smaller area. If you look at a place like the city and county of Denver, many of Dura's projects are very block and property specific as opposed to having larger urban renewal areas. Again, there is no right way to do it, no right model, but ultimately, again, the plan is approved by council, implemented by the urban renewal authority. And all the exercises of the powers of an urban renewal authority are intended to remediate blight. It is with that in mind that that is their primary objective. So when you look at what your urban renewal authority is doing, you're looking at it with an eye towards, are they doing their job? Are they implementing council's policy as it relates to the implementation of the plan, the elimination of blight? Next slide, please. So if there's one takeaway from this evening's presentation, it would be this slide. City council is the policy-making body. PURA implements the policy of the city. So there, as I said, there's no right way to do this. In Pueblo, you have a separate urban renewal authority. There are some communities where the city council acts as the urban renewal authority. But once a separate urban renewal authority, a separate body is created, as is the case in Pueblo, the only way that the power can come back to the city council is through voter approval at a regular municipal election. So unless you get voter approval, the Pueblo Urban Renewal Authority as a separate board remains. And there are certainly communities that have gone through that process in the past of trying to revisit how best to perform urban renewal and who is best to perform that urban renewal function. And so I thought it was probably appropriate to go through, at least in my view, the pros and cons of each approach. So next slide, please. And go one more if you would. So I would say that those municipalities that initially have the council as the governing body want what I would call the same level of accountability for urban renewal functions as for all the other municipal functions. And I am not giving a value judgment to whether that's a good idea or a bad idea. I'm just suggesting that is in many respects the policy decision that an entity that designates itself as the urban renewal authority is undertaking. So for example, in the town of Parker, the town council in Parker acts as the urban renewal authority. And when they created the urban renewal authority, they had discussions about whether or not it was a good idea to have a separate body. And they wanted to keep that function as well. Is it right or wrong? It worked for the town of Parker. But as with you as the city council, you wear a lot of hats. And so one of the downsides I would suggest to having the governing body act as the Urban Renewal Authority is you may lose some subject matter expertise. And it's no different than those communities that may have a separate liquor license authority or marijuana licensing authority, where the community decides that for a particular function, they want subject matter experts. And one of the benefits, next slide, please, of having a separate urban renewal authority is that you do create folks that that's all they do. And hopefully they become those subject matter experts. And there is some communities that believe there is value to the Urban Renewal Authority being somewhat insulated from being subject to re-election, because often urban renewal activities are not popular. You're ultimately seeking to eliminate blight, but in many communities, when you tell property owners their property's blighted, they don't understand that that is legal nomenclature. And it doesn't mean that their property is somehow undesirable. It means that it's within an area that meets the statutory criteria. But nonetheless, having that insulation as a plan is being deployed, being implemented, many communities think that is a positive. But it doesn't mean that the Urban Renewal Authority is acting independently of the city's policymaking function, because once again, the plan document is a policy document of the city. But the Urban Renewal Authority is not a department of the city. And so when we were talking a couple slides ago about the fact that it is a separate entity that can be sued and be sued, and what the Colorado law, when you identify an urban renewal authority, let's say if it's being sued or if it's a plaintiff in a lawsuit, it is referred to as a body corporate and politic. I'm not entirely sure what that means. I know it's a type of local government body, and I know it means it's a separate governmental body. And it is not a department of the city. Oftentimes in smaller communities, there is overlap with an economic development department doing some of the urban renewal functions. But at the end of the day, when you put your urban renewal hat on, it is in fact a separate entity as opposed to a department of the city. Next slide. So in 2015, effective January 1st, 2016, in many respects, the urban renewal world changed. And Pueblo has always been known for having robust urban renewal. Pre-House Bill 1348 in 2015 and thereafter. But as of the 2015 legislative session, taxing entities were pushing back on urban renewal, thinking that perhaps the tool was being overutilized or that they were being negatively impacted. And I would suggest those types of entities that were most concerned about utilization of the tool were counties and fire districts. And part of the concern was that there was not enough analysis of the impact on services of the other taxing entities when there was a new urban renewal plan area that was being considered, and that the other taxing entities weren't at the table. So what House Bill 1348 did is a number of things. First and foremost, it expanded the members of the Urban Renewal Authority Board of Commissioners so that there are at least 3 additional members. One who is appointed by the county, but need not be a county commissioner. One who is a member of the local board of education who must be an elected official, and one member who is an elected official of a special district, a Title 32 district within the plan area. And then oftentimes there are additional members to create an odd number. But the idea was to have those other entities be part of the urban renewal process in terms of the decision-making function of implementing the policy of the council. But what House Bill 1348 also did is required that prior to the ability to collect TIF as part of an approved urban renewal plan, that you had to have an agreement with all of the impacted taxing entities. The idea is if there is actually impacts on the services that those taxing entities provide, that they should get a portion of the TIF that's generated from the urban renewal project to offset those impacts. An example I like to use is a pre-1348 plan in another community where previously vacant property was developed into an assisted living facility. And at that assisted living facility, every time someone frankly fell out of bed, they had to call the fire district. And so in the before condition, you had vacant land. In the after condition, you had an assisted living facility that was having a multitude of calls for emergency medical assistance. There was clearly an impact on that particular fire district. And so part of the discussion with the impacted taxing entities is to address those types of impacts. And those agreements have to be entered into. And the Urban Renewal Authority is the entity that negotiates those agreements with the taxing entities, typically prior to it coming to council, so that by the time it comes to council, those agreements are in place and council knows exactly how the urban renewal, the TIF, is being allocated both to the taxing entities if there is impacts, and then ultimately to the project area. So that is a fundamental change. And next slide, please. This House Bill 1348 applies to new plans. It also applies to what are known as substantial modifications to existing plans. And I would suggest to you that any real modification to an existing plan under the language of the statute is going to be found to be substantial. It is going to be highly unusual to have a plan not be substantial. The only example I can think of is potentially compressing, as opposed to expanding, a plan area where there is not already any sort of debt that is attached to that plan area in a way that would allow a plan area to be compressed. That circumstance may not be a substantial modification. But if you're adding additional property, if you're changing the rules related to the plan, it's going to likely be a substantial modification. If you have a substantial modification to an existing plan, you have to go through the negotiation process. So the Urban Renewal Authority would be compelled first to negotiate with the taxing entities about the amendment to the urban renewal plan. And certainly with the new plan, the process I described. If the Urban Renewal Authority, for some reason, cannot reach agreement with the taxing entity, there's a mediation process that is compelled under the statute. Next slide, please. And these are the criteria that are considered for the mediation process. And it is really another way to say we're going to look at what the impacts are on the taxing entity that is going through the mediation. The first mediation under the statute was a number of years ago, and I sat as the chair. It was a sanitation district that was challenging the allocation of TIF up in the city of Leadville. And the discussion was about whether or not there was going to be any sort of disproportionate impact on the services provided by that sanitation district. It wasn't about whether the plan was a good idea. It was simply whether or not they were effectively being made whole. And when I say being made whole, I'm going to go back to one of my biases. The reason I believe that, urban renewal is a strong tool is when you're talking about impacts. If you believe that but for urban renewal, that development could not occur because of the conditions of blight that would make it infeasible, then the mill levy, the property tax generated from that property, is going to be very little. And absent urban renewal, the idea is there wouldn't be any additional mill levy generated. if urban renewal is successfully implemented, it creates tax increment, which is the additional tax generated from the redevelopment activity. And that is the dollars that are ultimately allocated to an urban renewal project. Put another way, absent urban renewal, there wouldn't be any dollars to share. And so the idea is that urban renewal creates that redevelopment activity, and the taxing entities are looking at, okay, as a result of that redevelopment activity, is there some sort of demonstrable impact to the services I provide? And remember that those taxing entities still get the base. And the base is that amount that was generated when the urban renewal plan was first adopted and the TIF clock started. And then the base grows with growth city or countywide, depending on how the assessor looks at things. But the base doesn't remain frozen. It actually goes up with essentially the inflation over time. And one of the difficulties the assessors have in implementing how to allocate base and increment is to allocate what is generated from the redevelopment activity, that's TIF, and what is not. And to the extent it's not, the base goes up as well. Next slide, please. The other significant revision to the urban renewal law is that when there is money remaining in the special fund at the conclusion of an urban renewal project, any money generated from property tax increment is supposed to be refunded on a pro rata basis. Practically speaking, I would suggest to you, and as I've said, I don't think you ever truly cure blight. But what the obligation of the Urban Renewal Authority is to assure that at the end of the 25-year period in which TIF is being collected, those dollars that are generated from property tax only have been pledged. They don't need to have been spent, but they certainly need to have been pledged to an urban renewal activity. Next slide, please. So I'm a bit of an urban renewal geek, and I will admit that. And so I'm going to talk about terminology because I really do think terminology, nomenclature is important. As we've talked about, the urban renewal plan, that is the policy document approved by the city council following a finding of the existence of blighted conditions. And it is a plan for a project. And I'll be the first person to say this is only a legislature could have drafted this language because it is incredibly ambiguous. But it is a plan for a project. And a project, when I think of a project, and you don't have the words urban renewal in front of it, I think of anything that's being developed. If the house next door to me was torn down this weekend and they're going to be building a new house, I think that's a project. Well, in urban renewal nomenclature, the project is the entire area. And each development activity within a larger project area is known as an undertaking or activity. So if you have a 300-acre urban renewal plan area and you're only doing something on 5 acres, the appropriate terminology is that is an undertaking or activity on the 5 acres as part of the larger 200-acre project area. Next slide. So when you have a lot of larger plan areas, it may include multiple undertakings and activities. You may have a project-specific redevelopment agreement that applies to an entire plan area. So I lived in an apartment in Five Points in Denver. That particular apartment that multifamily development was part of a confined urban renewal project. So it had one redevelopment agreement for the entire project area. However, if you have a larger multiple acre project area, you may have multiple discrete redevelopment agreements that pledge TIF from smaller property areas within a larger plan area. The Urban Renewal Authority also has the authority to issue bonds. Now, the definition of bonds under the Urban Renewal Act is much broader, and it is essentially any obligation of the Urban Renewal Authority. However, an Urban Renewal Authority does have the legal authority to issue what you would think of as traditional bonds, pledging tax increment that's generated from the property. And an Urban Renewal Authority is not subject to TABOR. Why is an Urban Renewal Authority not subject to TABOR? Because they don't collect their own mill levy. The tax increment that is the food that they rely on is generated from the mill levies of other taxing entities. An Urban Renewal Authority does not have in any independent taxing authority. It does not impose a mill levy. Therefore, you do not need voter approval to issue urban renewal bonds. Other undertakings and activities that urban renewal authorities specifically undertake in addition to redevelopment agreements is, as I indicated earlier, construction of public infrastructure. There may be facade grant programs, depending on the area in which an urban renewal plan is authorized for. It can be grant programs, it can be reimbursement programs. Again, there is no right way to do it, but all of those are options for implementing an urban renewal plan area. Next slide, please. Administrative functions. So one of the, what I would call wonky things about an urban renewal is the statute clearly provides for administrative functions. It provides for office space. It provides for the employment of staff and legal in counsel. It authorizes urban renewal authorities to create urban renewal plans for new plan areas to provide to the council for consideration. But it doesn't say anywhere in the Urban Renewal Act how those dollars are generated. So you know they have to be generated either from TIF or if there's an intergovernmental agreement, for example, between the city and the Urban Renewal Authority. So how do urban renewal authorities typically allocate dollars for administrative functions? Again, no right way or wrong way. But for example, in Aurora, they take a portion from each plan area and say that portion from each plan area will be dedicated to administrative functions. Other urban renewal authorities disproportionately utilize revenues from urban renewal areas that may not be as active. That's authorized as well. Again, no right way or wrong way, but administrative functions are authorized, and urban renewal authority monies are typically monies that are generated from TIF. And I think that is it in terms of my, yes. Now, I am happy to answer questions about things related to urban renewal I covered, things I didn't cover. But I'm open to any questions about urban renewal. But again, my message is, if nothing else, the only way this tool works is to be collaborating with the Urban Renewal Authority, so the Urban Renewal Authority knows what the council's policy priorities are, so it can implement the council's policy.
Perfect. Great presentation. That was, I was on urban renewal for 5 years and I needed that 5 years ago. Thank you for that. I did have one question right off the bat before I forget it. On the administrative functions, does that have to be included in the plan? So you get what I'm saying? So when you create the plan, is there a sentence that says so much is coming out of this for administrative functions?
It need not. It certainly makes it cleaner, but it need not. There's no requirement that that language be in the plan itself. And again, and I'll use Aurora as an example. Aurora and their council acts as their urban renewal authority, but they actually adopted a policy, an administrative policy that talked about how they were going to delegate those administrative functions to the various plans. So it was a separate document, not within the plans themselves.
So if the city council or the taxing entities aren't, it's approved by the Board of Urban Renewal, how those funds are come out?
Yes.
So essentially, the taxing entities have a voice in that. 'Cause if they're on the board.
Yes, absolutely, absolutely.
And
And for what it's worth, post 1348, I have not seen any votes where there's just 3 votes against. By meaning the 3 members from the other taxing entities, it has in practice been collaborative. So it has been successful in that respect.
Perfect. That answers my question. Anybody else have any questions? Counselor Flores?
Yeah, thank you for that information. Very valuable. What is the, and this could vary, I guess, but what do other communities do when they have a separate autonomous urban renewal in the selection of their board? We have bylaws and we have all of these things that really, when you look at the Pueblo Urban Renewal Authority, you feel that they have their own autonomy, their ability to to function as a separate entity. So what is where are we then with the selection of the board members to Apura?
Minus the 3 board members from the other taxing entities. It's the mayor's appointment with the consent of the governing body. That's what the statute says. So it is typically it's a resolution that says, and I'm not sure how Pueblo has done it historically, but and I don't know enough about the form of government here to know whether it's different in practice. But in those communities that I represent that do not have a strong mayor form of government, it's a city manager form of government. It's still a mayoral appointment, but approved by the governing body. And that's how you get the consent of the governing body, by resolution. Now, is there a vetting process? Absolutely there is. And each community does a different vetting process. Some do interviews with the entire council. Some will do interviews with the mayor. But I think the goal is to find folks that have some level of expertise and, in my mind, policy alignment with the city council, because that's the goal. We have a term that is the opposite of collaborative in the urban renewal context that we used to refer to as rogue urban renewal authorities. And that's that unfortunate circumstance where perhaps they are acting in a manner that is inconsistent with council's policy. There is a process in the urban renewal law, and I feel compelled to tell you it, although I would hate for anyone to ever have to use it. But there is a provision for removal of urban renewal commissioners for cause. I have seen that happen in a couple of communities. It's not a good place to be. And so the goal is to have that alignment at appointment. So you have an urban renewal authority that, again, understands the role to implement council's policy, is a subject matter expert, is autonomous in terms of implementing the policy, but that autonomy should still be consistent with the council goals. Did that answer the question?
Yes, it did. Thank you. We had a situation a couple of years ago when we executed some bonds for our steel plant here in Pueblo. And there was a water district that refused to sign off on this. And they basically represented, I think, less than 1%. It was a very minor amount. And we found ourselves in a situation of kind of postponing decisions for quite a few months during that period. Is there any way of isolating somebody that represents such a small amount to get them out of the way in the event that they're jeopardizing? This was a huge project, bonds that were close to $100 million. And it was really an important project for our city.
I mean, practically speaking, I think there's two ways. One is to simply have their mill levy, to the extent it exists, pass through and go back to them. The other is to go through the mediation process. in my experience, unfortunately, time is money. And while the mediation process says it's 120 days, in the Leadville example, it probably took a year from beginning to end in terms of the process to appoint the mediation panel, finding the dates, having the hearing, and then having a decision made. It took close to a year. And so if there is any way to avoid the mediation process, I always recommend that. And at the end of the day, the obligation relates to the mill levy. And if you pass the entire mill levy back, then they're getting everything.
My last, I guess, comment or question, there might be a question in there, is that you have in Pueblo, we have many contractual relationships. Three of them that I can think of is our zoo. We have our animal shelter, and we have a park up in Beulah, which is a small community up in to the west. I always looked at those entities as professional people, like the zoos run by a zoological society, people that are professional in what they're doing. Same way with the Humane Society of the Pikes Peak region that runs our animal shelter. And we've got another entity that manages. So when I look at a government like ours, it makes me feel good that we've got people that are doing a great job, because that is their passion and that is their reason for doing the things that they do. And those relationships are very valuable, not unusual. I'm sure other cities have the same thing. Tell me where, I've always looked at urban renewal on the same basis. And I'm going to give you an example. It's possible that on January 1 of this coming year, that's just 3 months away, that we're going to have 4 brand new city council people. That's the majority. And but the consistency of professional people that are handling urban renewal is so important to me anyway. And at the end of the day, you know, everything has to be ratified by the council. But you know, to what extent, I guess, you keep saying the city council is responsible, we're going to make policy. A lot of times, you know, they're bringing information to us because they have a very busy working board. And it just seems that tell me where I shouldn't look at urban renewal like I do the animal shelter or other contractual arrangements.
When councils change, I think there's 2 pieces to this. One is certainly the education component and trying to get a new council educated on urban renewal off. And I would suggest that those subject matter experts, if the relationship is collaborative, are the best people to start with that. But the other, for those entities that have separate urban renewal authorities, they typically have a liaison to council, someone on the city council that is also on. I can't emphasize enough the importance of that individual council and sort of in being the liaison. And I know that you all are pulled in a lot of directions, but I certainly believe having a joint study session once or twice a year to look at big picture policy things, look at what matters to council so the Urban Renewal Authority knows what matters to council, hear Urban Renewal Authority's feedback on how it believes those policy concerns can be implemented are critical. And again, I'll use Arvada as an example because they too have an election coming up in November where they're anticipating having new council members, which is why when I do this presentation there, it's going to be in February. And part of that discussion is going to be the Urban Renewal Authority asking council, how do you want us to go out and do this? And likewise, council saying, I want you to look at these areas in addition to the areas you may want to look at. So it is that collaboration. And in Arvada, the mayor is the liaison. And so she's both the mayor on council and then she's also a member of the board of commissioners on urban renewal. And she's got a heavy lift to be liaison between the two boards.
I do have one other question, and that is, run us through, obviously, urban renewal authorities have the right to execute bonds and incur debt. Give us kind of the parameters of while the responsibility obviously is through those project areas and the generation of TIF to pay off the bonds. But could you walk us through just what that authority really is? And obviously, at the end of the day, the city has to ratify that too. So I guess we're in the game ourselves as a city.
Well, and with the caveat that I am not a public finance attorney, so that is not the area that I practice in. Typically it is an urban renewal that just issues the bonds. In absent a moral obligation pledge of the city, the urban renewal authority can independently issue those bonds. And you know, there are folks that do the analysis to assure that TIF is being generated is sufficient to pay off the bonds. There's questions as to whether they may be tax exempt. So for example, if bonds are going towards public infrastructure, they will likely be tax exempt. And there's other models. So it is not uncommon for an urban renewal authority to pledge TIF to a special district that may issue bonds. And one of the advantages to doing that, special districts have less authority in terms of what they can pay for out of indebtedness. And if an urban renewal authority is pledging TIF towards special district bonds, it's really limited to public infrastructure. And there are a lot of urban renewal authorities that want that limitation, that think that TIF should be used more towards public infrastructure than what I'll call private redevelopment. But ultimately it is the question for those that approve bonds is there going to be enough TIF generated and pledged to pay back the bonds?
There's one area that I've always been, it's been nebulous to me. Obviously, you know, we want to help those blighted areas and in the actual project area. Every once in a while, we run into a situation where we need to do, and one of the examples that's really been a problem here is the involvement of urban renewal with structures that have been burned. And so, you know, it's very expensive to remediate a burnt out building. Is there some authority that urban renewal has to take care of issues? There might be somebody that's right in the middle of an urban renewal project, but for some reason was left out. They might sit right across the street, and they need help, you know, in removing maybe asbestos, or they might need help in with their utilities or whatever. How far outside the project areas can an urban renewal venture out to?
So and I'm going to get the year wrong, but within the last 15 years, the urban renewal law was amended. There used to be language in the statute that said the expenditures had to be within the area, and that was actually taken out. But urban renewal is to eliminate blight or prevent the spread of blight. So there's no answer, is it a half a mile, is it a block? But you have to show the nexus that is preventing the spread of blight. I can give you a couple of examples. If I'm building a detention pond that is outside of the urban renewal area, but is clearly intended to handle drainage within the area, easy. Clearly benefiting within the urban renewal area. At roughly 106th and I-25. North Glen, the Urban Renewal Authority there funded a pedestrian bridge over I-25 to connect the urban renewal area to the residential areas in North Glen. Again, the connection there was to benefit the urban renewal area, prevent the spread of blight. So it is clear that it doesn't have to be spent within the area under the statute, but you have to show the nexus that it is consistent with the plan and preventing the spread of blight.
Thank you.
Thank you. Councilor Maestri?
Yes, thank you, Corey, for coming. For most people who know me really well, know I like educational training. And so this is like Christmas for me. So be patient for me with me because I have a few questions, quite a few questions. So is council really considered the governing body over urban renewal? When we set policy, right, and we're to monitor that, are we somewhat of a governing body? How would you explain that relationship?
So the statute refers to the governing body.
Mm-hmm.
So, I'm gonna give you the caveat that I am not an expert on Pueblo's form of government and the relative powers related to the mayor and the council. But at the end of the day, under the statute, the policymaker, the one that adopts the plans,
Okay,
is
The
the
governing
city
body.
council.
okay. And in relation to the city council's policy, it should probably be updated as time goes on because things change over time. Maybe, yes, no,
So here's how I would look at that.
okay.
The urban renewal plan should not be updated because frankly, every
No,
time
the
you,
policy,
but the urban renewal plan
Okay.
is the policy
okay,
document. And so Pueblo's urban renewal plans are very similar to urban renewal plans in most jurisdictions
Okay.
in that they are not specific. They're templates, they're frameworks about the types of things that are authorized within a plan area.
mhm,
And so the urban renewal plan policy document, I would suggest, need not be amended.
okay.
And frankly, if it is amended, the process is so long and rigorous under House Bill 1348 that it's going to potentially unduly delay actually implementing. But because it is a broad policy document, the city council's interpretation of that policy document is what should be the discussion, in my view,
Okay,
between the city council and the urban renewal authority. Because let's say a plan was adopted in 2010,
mhm,
and then in 2015, the city council adopts a new comprehensive plan applicable to that area.
mhm,
Well, in 2010, they had to show it was in conformance with the plan that existed at that time.
okay,
The comp plan may change. The urban renewal plan stays in place, but that's where the conversation happens in my mind with the urban renewal authority and the city council to say, okay, here's where we are now. Here is our policy as it relates to this area. You can still use that original urban renewal plan to implement whatever those changes may be. It's going to be very rare that something has changed so dramatically that the urban renewal plan doesn't still apply.
okay. So the policy is the plan itself.
Yes.
And is that plan when you're writing the project detail, okay, say the plan detail, is that where you would be like using what's the language in the plan, or would you be saying, example, you know, from B Street to C Street on Union Avenue, these things are going to be taking place? Or do you just leave it broad and open for interpretation? Because I guess maybe the concern is, what if nothing gets done?
Yeah, and I would say for a larger plan area, the larger the plan area, the less specificity. And so that you do have that flexibility. And you also don't know the order in which redevelopment may occur in a larger plan area. And that too that gives you the flexibility to react. Whereas, the plan with the multifamily, the apartment building I lived in Five Points, much more specific because it was literally one multifamily. That was the project. So
Mhm.
that was going to be much more specific than a larger plan area that may redevelop
Okay,
over
so
time.
a small singular specific should specify this is what's going to be where.
Yes.
Okay, so once a plan is fully approved, when does the TIF reimbursement start?
Well, it's up to, so the plan doesn't create the TIF reimbursement.
Okay,
The plan creates the authorization to collect TIF.
okay,
You can have any obligation of the authority triggers the entitlement to TIF.
okay.
So frankly, if the Urban Renewal Authority having to pay its staff
Mhm.
is an obligation that authorizes TIF. But what typically provides reimbursement
Mhm.
is going to be a separate redevelopment agreement.
Mhm.
It could be,
So that's with the developer.
yeah, it could be
Okay.
that. It could be an agreement with the city to build infrastructure.
Mhm.
It could be any of those types of agreements that trigger TIF. It could be a facade reimbursement with a property owner. Any of those types of agreements, will often have multiple reimbursement agreements, redevelopment agreements in larger plan areas.
But those should be specified in the plan.
No, typically they wouldn't be. They typically
Okay,
wouldn't
so
be.
why would you, where would you make that agreement at then?
Those agreements are between the Urban Renewal Authority and the redeveloper. And that's why the process to get there of making sure that as that's happening, that they are implementing the plan consistent with your vision is
Mhm.
happening as part of the public process. But that's also where Urban Renewal has the autonomy
Mhm.
to enter into those agreements. Where the process gets, in my mind, off the tracks
Mhm.
is if the Urban Renewal Authority is entering into agreements for redevelopment that are inconsistent with the vision of the council. They have the authority to do that if it's consistent with the plan,
Mhm.
but it's just not good urban renewal practice. And that's why I keep talking about collaboration as the mechanism to assure that doesn't happen.
Okay, and what about, so we determine that an area is blighted, say it's a single project. Are we, and there's a third party study, it seems like. Does that study go out for like RFP or an RFI, or is it just, can the urban renewal just choose the same company all the time? How does that work?
Again, no right or wrong answer.
Mhm.
Different urban renewal authorities have different policies about how they hire consultants.
Mhm.
It is professional services as
Mhm.
opposed to a public improvement project. So it's going to depend on what the urban renewal authority's policy is. If they're the ones that are doing the condition survey,
Mhm.
if they do it as part of a response to an RFP or not.
Mhm.
Many communities do that, others don't. There's probably a handful of entities that do this stuff well.
Mhm.
And so again, it can be done either way. There is no requirement in the urban renewal law
Mhm.
that the consultants go out to an RFP.
Okay. And then what about, when you talk about the reimbursement or the operating expenses for urban renewal, is there like a customary set of, rates? When, like, say we're looking at a $15 million cost in the plan, is there a certain percentage, or how does that work?
There's not. Again, some will do a percentage off the top. Some it might be a sliding scale depending on the nature of the project. There might be somewhere every dollar potentially has to be pledged to the redevelopment activity. And so
Mhm.
there might be a decision made to exclude a particular plan area from offsetting administrative costs. There's really no right way to do it.
Mhm.
You know, do I think that from a best practices perspective, and this is not statutory,
Mhm.
but best practices is that, it's transparent in terms of what is coming out of each plan area for administration, and you can do that in a budget document. But there's nothing in the urban renewal law that says you have to take administrative expenses from each plan area.
Mhm. And when they talk about suitable office space, does that really allow for the purchase of an office?
It certainly could.
Okay.
Yeah.
All right. And then is the TIF based off of what exists? The rate, is that where it starts? The TIF, like, of what the existing plot or area is, they take that total that's generated there. And is the TIF based off of that, or does it grow? Well, what grows is if you develop and then you create more property tax, correct?
Yes. So TIF is generated from redevelopment activity.
Mm-hmm.
So at the time the urban renewal plan is approved, the base is set. That is the revenue generated from the mill levy at that point in time.
Mm-hmm.
And then if there is redevelopment activity that triggers higher values, the dollars generated from that redevelopment activity at that same tax rate, that is the TIF.
Mm-hmm.
And, the law has evolved in this area as well. There was a Colorado Supreme Court case, I think it was 2023 now, arising out of Arapahoe County, that essentially says that redevelopment activity based on what the property tax administrator determines is by and large going vertical.
Mm-hmm.
So it is the what's called project influence. Oftentimes property value will go up when property owners know a plan is coming.
Mm-hmm.
That doesn't create TIF.
Mm-hmm.
It's got to be the actual redevelopment activity.
And on a single project, would council need to be concerned about whether there is the monies for the project have been verified rather than waiting? Because why would we be, voting on a TIF district, it's a single project, and then come to find out there isn't money for development.
That
Where's the,
it's a
'cause it's
policy.
a 25-year, right, once you do it?
Once you start the clock, yes,
Mhm.
it is a policy question. Now, is it most common for urban renewal authorities to do some sort of feasibility analysis, have a third party assure that there's actually a gap?
Mhm.
Absolutely.
Mhm.
That in my mind should be part of the process, because urban renewal is not an entitlement program.
Mhm.
It is a program to eliminate blight.
Mhm.
And practically speaking, the way that urban renewal agreements work
Mhm.
is the only way that TIF is generated is if there's redevelopment activity. So if you enter into a redevelopment agreement and nothing happens,
Mhm.
there's no downside to the urban renewal authority because it's not paying out any TIF because none's been generated.
Mhm. Now, say something has been approved and it can't go through because of financing or money problems. Can that be transferred to like a new buyer that maybe buys the same idea from that developer that doesn't have money? Would that be able to transfer right into that?
Without knowing the details, but typically the answer would be yes. Typically, the urban renewal authority is entering into agreements to eliminate blight
Mm-hmm.
through providing TIF.
Okay.
How you get there are so many different paths to get
Mhm.
there, and there's no right way or wrong way.
Okay. And what happens when you determine a single project and then that project never takes off? But sits there in a TIF single?
Yeah, I mean, probably nothing. I mean, can you, I have seen an urban renewal plan essentially repealed. I think that was unnecessary,
Mhm.
but in that context, there could not be any debt, any obligation whatsoever of the Urban Renewal Authority in that area to allow that to happen.
Mhm. And say you make your boundaries and it's a large area. And one block over, maybe say a new hospital is going up. Would you want to, before you finalize and approve that plan, change that boundary line?
Again, it's going to depend. There's so many factors in terms of whether it is kind of
Is
compatible.
it something you could do, I guess?
You could, and if you're doing it at the initiation
Mm-hmm.
of the plan, that's the time to look at
To do
it.
it, yeah.
Because otherwise you have to go through the process for 1348.
Mm-hmm.
And I think what some communities do is you may do a condition survey for a large plan area.
Mm-hmm.
That doesn't mean that's going to be the plan area that's ultimately approved. So, I have a client right now that has just commissioned a very, very large area for the condition survey,
Mm-hmm.
really to determine what's possible. Not that that is going to necessarily be the boundaries of the plan area that the city council ultimately approves. They're
Mm-hmm.
going to, they may see a large area that has blighted conditions. That doesn't mean that entire area is going to be a single urban renewal plan. It may be two, it may be one in some areas that aren't included, but they will know what the conditions are and can make a decision as to what, from a matter of policy, is the
Mm-hmm.
appropriate urban renewal plan area.
Mm-hmm. Okay, and when you talk about money being refunded, it does have to go back into to the property tax?
It is only it is only dollars generated from property tax increment.
Mm-hmm.
But if all the work has been done
Mm-hmm.
and there is no remaining obligations of the authority and there's money left in the special fund and it's not pledged towards anything, in that unique circumstance under the statute, it is returned, the dollars generated from property tax
Mm-hmm.
are returned pro rata. I've never seen it happen. The statute's
Yeah.
there. I've never seen it happen.
Can you use it for operating expenses for Pura?
You can.
Okay. And let's see. Yeah, the single projects are really interesting in the detailed plan that you said that should be necessary under a single project.
It need not be necessary. It is more common for a single property to have more detail because you're typically a developer is initiating the project
Mhm.
and has a specific vision that is then incorporated into the plan. There's no obligation that a single property project have a level of detail, but it's more common to because it is the developer coming and saying, this is what I want to do. This is how I intend to eliminate blight. This is my plan.
Mhm. Okay. All right. It seems like there's a lot of leadway with public funds. I mean, I'm not against urban renewal. I'm not against the whole concept of urban renewal, but it seems like there's a lot of leadway with public funds.
Yeah, I would say it's flexibility, but there is absolutely. I mean, it is intended, but that's why goes back to what my theme is. That's why I think it's critical that it be collaborative,
Mhm.
because these are public dollars being used for a specific statutory purpose, which
Mm.
is to eliminate blight, prevent the spread of blight.
And so in that collaboration, you're saying that this council or the body should be cognizant of making sure that it's being held, there's like some responsibility or there's some accountability to how it's being done.
I certainly think that is the best way to implement urban renewal in a community.
Well, thank you, because, I think we've had an attorney that's wanted us to be a little bit more accountable with urban renewal plans in the past. And thank you for validating that. I appreciate it.
All right, we good? Counselor Flores.
But wait my turn.
I just
Counselor
have one
Boston.
question. You had a lot of great information there. Thank you, Corey. You must know the last director we had because a lot of things you said are very similar to a lot of things he used to say. So I'm sure you've met him before.
Mr. Pacheco?
Yeah.
I've certainly met Mr. Pacheco, yes.
Yeah. I got the opportunity to sit down with him when I first got on council, and he taught me a lot about how the authority worked. And the biggest thing that you brought up tonight that I thought was unique for me and my perspective is wasn't aware that sometimes the council was the urban renewal authority in some different communities. What would you say is more common between all the different communities? Is it what we have here, or is it what you were saying was in Aurora?
I think it's probably a pretty even split.
Have you personally seen which one you think functions better? I know you gave us pros and cons, but
Yeah, no, I mean, I really think it's a community sentiment. And I'm gonna pivot and give the example of liquor, because a lot of the communities I represent delegate the liquor licensing function to either a hearing officer or to a separate body. The reason they do that is because they don't feel like they have the bandwidth to develop the expertise. And so I really think that's probably the most common reason to have the separate urban renewal authority, is really to have those subject matter experts so that council can focus on policy. Just like in the liquor licensing context, they don't want to be doing renewal hearings on liquor all the time when you have a lot of other policy stuff. So to me, that is probably the most common reason and basis for having that separate urban renewal authority. But again, I think it is probably more common in smaller communities to have the council or the board act as the urban renewal authority. Two reasons. One is, practically speaking, it's going to be harder to find board members. But I think in a smaller community, it's probably easier to take on that function than it is in a bigger community.
thank you.
Counselor Flores.
Urban renewals are allowed to transfer land. I'm curious if you have an opinion. We also have an economic arm here in Pueblo called PEDCO, Pueblo Economic Development Corporation. And then the city also owns land. So if you're looking at a blighted area and a developer is willing to go in there and start a housing project, as an example, what is the best way to transfer the land? I mean, if the city has the title, is it better to give urban renewal the land and then have it developed? Or should we go directly? Or PEDCO has, our economic arm has a lot of land, and they use that as part of our incentives and incentivizing companies to come in. But PEDCO also manages what we call our half-cent sales tax, which is really city money, but they do the vetting. And but they also have title to what I call spec buildings and land. But I'm curious as to your opinion as to how all that should be handled, or maybe.
Yeah, I don't think there's any right or wrong way to do it. And I've seen, again, if the municipality and the city, and in this case PEDCO and the Urban Renewal Authority are all working together, who actually holds title is probably less important in terms of who transfers title to the ultimate developer. I think there's a couple of issues that are embedded in that question. One is, in my mind, if you want to maximize TIF, you have the government own if the government already owns the property, you wait until the plan is adopted, then convey the property, you maximize the TIF because it goes from being tax exempt to then taxable, which creates more potential TIF as it relates to actual dollars generated. one of the difficulties in urban renewal that we all deal with is when you are conveying property, what's the moment in time where you convey it to assure that the project actually gets done? And what mechanisms do you have in place if it doesn't get done to perhaps get the property back? And that is, practically speaking, often a difficulty. Do you have an obligation that if the project isn't commenced within a certain number of years, you buy it back at fair market value? Do you buy it back at the value you sold it plus any dollars they put in? Can you put a deed restriction on it? And some communities try to put deed restrictions on it, and then it's very difficult to finance. So there's no right way to do it, but I think the goal ultimately is to wait until you know that it's ready to develop.
And my last question has to do with hiring consultants. That seems to be a decision that can be made by urban renewal without
Definitely.
ratification from council.
Correct.
Thank you.
Councilor Maestri?
Are there any conflicts with who purchases the bonds?
Again, I am not a public finance attorney,
Mhm.
so I don't know enough to know to answer your question.
Okay, okay, thank you. Going back to Mr. Boston's question, where he was asking about council, what I thought was very interesting for council to consider is what you said, that even though it's even when it's a separate body, that it is our due diligence to make sure that that body is equipped with board members that know what they're doing, as well as the team, right? The team, to make sure that they know what they're doing. And I think that's one thing that we really need to consider when we are approving the appointees, is what is their background and so forth. If we continue to, go as we've always gone. So we really need to give consideration to who is on the board, and because this is probably one of the very important next to economic development as far as boards go. Okay, thank you.
Anybody else? All right, thank you.
Can I
Yes,
Sorry.
of course.
just had a couple of questions? When you are talking about developing policy, can you give some examples of maybe how some of the other jurisdictions that you work with, how their councils express their policies to urban renewal so that they can make sure that they stay on the same page?
It is typically a couple of different ways. Certainly the comp plan is the overriding policy document for a given property area. But it's frankly often through the liaison. It is through having touch bases throughout the maybe one or two study sessions a year, joint study sessions. But the policy document itself is already adopted, which is the plan. So it's a matter of having that touch base to say, this is how we interpret the plan. This is what we are looking at. It's typically not a written policy document because that's the plan.
So when they have these touch base sessions, these sort of study sessions, do they typically talk about one particular district or one particular project, or is it more conceptual? Like, for instance, you said as a city council, they would tell urban renewal or direct urban renewal, we want you to focus on infrastructure more than private development, or we want you to do this more than that, or is it more specific, them holding them accountable on specific district areas?
It can be any of the above. It's going to depend. I mean, frankly, Pueblo has a lot of plans.
Right.
It has, I would say Pueblo, Aurora, Denver, seem to have the most individual plans. But it can be at a high level, it can be at a granular level. But at the end of the day, I mean, you can't force collaboration, but if that collaboration is there, you don't need the specificity that you're talking about because it's kind of natural. As you're talking about, look at this area. This area is deteriorating. How can we collectively address it and make it better? What's out there?
Do you have any suggestions for city council on how they might work as a group to build a consensus so that they can, between themselves, have a cohesive idea of and be to relate to urban renewal?
Probably beyond my pay grade as legal counsel. I mean, I would simply say building consensus like they do on any other policy issues. Whether it's, I mean, I have clients that do economic development retreats that do them individually, get the information, and then bring that back and say, we think this might help from an urban renewal context and work with their urban renewal as a result of that. I don't know that there's a right way to do it.
Okay. Thank you.
All right.
Sure. Yeah, that's-
Counselor Maestri.
In regards to her question, that's when I was just getting ready to say that maybe council needs to consider, the policy's really already been set in the plan, but maybe what we should talk about and have an open discussion at some point is procedural. Because what we can, and what I mean by procedural is maybe come up with get together with urban renewal and collaborate on, hey, this is the expectation. This is what we would like to see. We'd like to open the doors of communication and be a little bit more, like with our economic development company, they come in a lot of times between their working with the client, starting the work all the way until approval. And maybe we just need to get together and come up with something with urban renewal that works for both of us. Like you say, it's just opening the doors of communication to set like a little expectation on how it runs.
Yeah, and I have an urban renewal client that makes a report to council. It used to be quarterly, now it's twice a year. But frankly, whether they need it or not, they're on the agenda twice a year to do a presentation. This is what we're up to. And it's a good touch point. It's in a community where urban renewal is probably less active right now, but it's that touch point to make sure that they are aligned.
Yes, thank you.
We good now? All right. Thank you very much.
Have a good night.
Probably see you in February. All right, we now move to Pure Loan Forgiveness, Cherish Deeg and Chris DeLuca. I don't see Chris DeLuca.
He's on.
Okay.
All righty. Thank you all for having us tonight, and that was great to have Corey here. We have been in conversations with the administration and PEDCO on a weekly basis, so I think that touch point is definitely getting better between the city and urban renewal, and we'd be happy to work with you on anything that you want. Tonight, we're here to talk about the RTA loans with the city. There's two. I put this little presentation together to do a little overview of just RTA as a whole, and then we can talk about the loan. I know that you guys are probably familiar with most of this, but to get started, you can go to the next slide, please. RTA funding from the state. We've currently received 25.7 million through August of this year. The grant total allocation is 35.7 million. So we have a balance of 9.9. We are receiving 3.3% of the state sales tax at this time versus 27.7%, which is what we were receiving when it started. Next slide, please. This slide just talks about each of the funding sources for the project overall. We had this state sales tax increment, the bonds that we issued based on that state sales tax increment the loans from the city, which is a 2.2 and a 12.2, a total of 14.4. Other funds that were available as far as urban renewal TIF dollars, et cetera, some vendor fee for some repairs on the convention center, and the grant funding. The city had an EDA grant and a DOLA grant that did some improvements on HARP. So that just kind of walks through all of those funding totals. The next slide just talks a little bit more in depth about those totals as well. I can go into more detail if you want, but we'll go ahead and go to the next slide, please. This is a conversation that Urban Renewal would like to have with the city regarding the loans themselves. The state sales tax increment is eligible to pay for interest only on those loans. It is not eligible to pay the principal. The state sales tax increment goes to PEDCO to repay those loans as the loan was given from the half-cent sales tax fund. The total for 14.4 was split into two parts, as the 2.2 was dedicated as a grant match to the HARP improvements. And the promissory note for that one does not have interest. The 12.2 does. 12.2 funded a lot of things for the PBR Sports Performance Center, now Da Vinci Museum, some of the parking garage, the equipment, et cetera. These are pledged by or secured by a deed of trust on the convention center building itself. And what we want to do is to talk about forgiveness of this loan or these loans, and the total interest that the PEDCO fund has received to date is $1.7 million. And it's at a 3% interest on an annual basis, which is about $366,000. Next slide, please. The idea and conversation at this moment is the Main Street parking garage is owned by Urban Renewal. We have a ground lease with the city, so the ground is owned by the city. The building itself is owned by Urban Renewal. It was paid for by TIF dollars and tax increment, new market tax credits, I apologize, for the actual building itself. And the Urban Renewal issued a revenue bond on TIF, so the building is actually free and clear at this time. We have completely unwound the new market tax credit deal, and it's free and clear. The current estimate of which we have an appraisal that's several years old. We are working to get the building appraised. Sursa has appraised it. I'm waiting on seeing if I can get that appraisal, but we believe that the Main Street parking garage would satisfy the full 14.4. And our question to the city is, would you be willing to work on transferring the ownership of that garage to the city in satisfaction of this debt? Mostly this supports the collaboration, the economic activity, the redevelopment of the downtown. We want to make sure that the city has a smooth transfer of this ownership. There are lease agreements within the parking garage, as well as the city utilizes some of those spaces, and the AT&T lease for parking is probably going to expire, which we'll talk more about in the next slide, but there are also other opportunities for the building itself. Next slide, please. Some of the potential for the city, if you do move forward with this discussion with Urban Renewal and forgiveness of the loan or satisfaction of the loan. The agreements for lease are about $86,000 a year. 32 of that is just regular lease agreements, and then 54,000 is the AT&T lease. They are pledged currently to a 60-40 split of the operation and maintenance of the garage, as well as the debt in the area. So 60% is Urban Renewal's responsibility, 40% is the city's. We work with the city maintains the building, spends all the funds to do that. takes all the invoicing and receives all the payments. We split the debt 60-40 in the year for the year, and at the end of the year, we do a reconciliation. Urban Renewal pays for insurance and other items on the garage as well. So that kind of washes out at the end, and either Urban Renewal owes the city or the city owes Urban Renewal. And in the past several years, it's been about $80,000 that the city transfers Urban Renewal in this 60-40 split based on those lease revenues and the expense for maintenance, et cetera. So in this conversation, Urban Renewal would ask the city to keep the 60-40 split on the debt itself, but remove that from the operation and maintenance so the city can remove the need to pay Urban Renewal any funds in the future. You would be able to retain those lease revenues for maintenance and operations, or however that works out in the finances. As well as the building is free and clear from that debt. It is an Urban Renewal TIF revenue bond. So the building could be an asset for the city to use for COPs or just a general asset of the city. So that's definitely a plus for that. As well as Urban Renewal is currently working on a lease with AT&T to put antennas, 3 antennas on the building for an additional $2,200 a month lease, which doesn't quite cover the parking lease, obviously, but it is additional revenue, as well as there are potential additional parking leases for the potential hotel on the HARP office sites, et cetera. So next slide, I think, is our last one. That's really what we're here to discuss. I'd be open to any questions. Chris, I don't know if you're on, if you have any other comments, but we're just here to broach this idea with the city and see what you all have questions and if this is a good idea in your eyes.
Well, I'll start off because I guess I have big questions about it. So the big question is that city council at one point says we will loan Urban Renewal this amount of money in order to get the convention center expansion done and so on and so forth. They changed the criteria ordinance. They made all kinds of concessions, and they loaned the money to Pura. So I understand how you're proposing that, but somehow, some way, that money has to go back into the half-cent sales tax fund. So a transfer of property is fine as long as the city wants to buy the property and then put the money into the half-cent sales tax fund. That seems like a doable deal. But I don't know that the city has $12 million to pay for the building and then reimburse the half-cent sales tax fund.
So it wouldn't be a cash transaction. The
what
property
I'm saying.
itself would be carried as an asset in the half-cent sale.
Exactly, but that the voters, when they approve the half-cent sales tax, if I own a business and I don't pay my sales tax, the first thing the municipal judge is going to tell me is that I'm stealing from the people of Pueblo by not paying my sales tax. And I'm held responsible for that, and I have to pay it. There's no choice. I have to. I don't know how this is any different where that money's, I get you have the asset, but the half-cent sales tax fund is short $12 million. How's that going to be reimbursed?
So I guess you have kind of a chicken and an egg question here. The original intent of the 14.4 was a WEDIT when they were working through the grant application with the city of Pueblo, said we need to see local buy-in. We need to see that the community wants this project. They want this funding to come to Pueblo. So part of that conversation was, okay, the city and PEDCO, this is how we're showing the local buy-in in this project. It worked out to, okay, Urban Renewal is going to do the construction project. And so that needs to be a a loan, a grant, whatever to urban renewal. Council at the time said, we'd like it to be a loan and we'd like part of it to be interest bearing.
Part of it to be what I didn't.
Interest bearing, sorry. So OEDIT said, okay, that's great, wonderful, we love the buy-in. Yes, you can pay interest on that, but you cannot pay principal. Urban Renewal Chairman at the time, Don Banner, spoke with the city attorney and the council and said, we do not have an eligible way to pay the principal on this. You can take the convention center. That's basically, if we do nothing and we don't work through this, the convention center will ultimately be your asset to satisfy this debt, because urban renewal TIF dollars cannot be allocated to this debt. So it kind of just was, well, this is what we wanted, so that's how it worked. Now we're just trying to work through how to satisfy that debt in a legal way to give the city an asset to satisfy that $14.4 million. And as well as the HARP assets that the grant funded is also a city asset. So the 2.2 that was a grant match for the EDA and DOLA grants funded the Gateway Plaza HARP expansion, as well as some boathouse expenses, et cetera, are being discussed at this time for RTA as eligible items, but we cannot pay TIF dollars to pay back principal on this. So this is just an opportunity to give the city an asset that could become cash with a COP or something like that as an asset of the city.
Okay, but you understand my concern. I understand the city gets an asset,
Yes.
but the half-cent sales tax, which is a whole separate entity, a whole separate entity. So the taxpayers of Pueblo said, we'll give half-cent sales tax out of our or out of our taxes that we pay within the city to go towards economic development in that half-cent sales tax fund. The city council at the time, I have no idea. I mean, maybe Councilor Flores, as we move through this, has some insight into that. I have no idea why city council at the time decided that it was a loan.
Right.
And why that was put in place like that. But the fact is that it was obviously sold to the city, to the constituents of the city, that this is a loan that will be repaid and it will go back into the half-cent sales tax fund. So I'm not opposed to doing anything as long as the half-cent sales tax fund is reimbursed the money that was loaned out. How that works, I don't know how it works, but our fiduciary responsibility is to the taxpayer, and if there's a loan out there, we should get the loan paid back. That's my whole argument on it.
Understood. And I agree. I'm not sure at the time the conversations loan versus grant, because as far as I'm not attorney, but the way that the criteria was amended, it could have just been funded by the half-cent sales tax and not loaned with an estimated payback. Now, the half-cent sales tax has received $1.7 million in interest on this from the state sales tax increment, and will continue to be paid that at a 3% interest rate until there is either no more RTA, state sales tax to pay it, or something is worked out, or the maturity date on these loans comes and the convention center becomes an asset of the fund. So I think at this point, we're talking about a different asset satisfying that debt versus the convention center in an earlier time period to be used as collateral or something for the city and the half-cent sales tax now versus in, I can't remember what the maturity date is, 2027 with an extension of another 10 or so years. Yeah. So I think that's where we are. And again, like you said, we don't really know exactly what the conversations were when these original loan discussions took place, but that's our proposal.
I guess we just have to assume that there was a reason that they did it that way. And
Can I jump in too, Mark, if you can hear me?
who's this?
Chris.
DeLuca.
Sure.
Hey, so I guess when we discovered this, at probably, 6 months ago at this point, I think we're just trying to clean up the wrongs that were done years ago. It sounds like this was signed, sealed, and delivered with no intent to pay the sales tax or the half-cent sales tax back. That the convention center would just be signed over and here you go. This is a good way, I guess, for us to be able to, I guess, right that wrong of years ago. So that's kind of why we proposed what we did. We 100% understand what the optics are and how bad this was years ago, but at least we can come to the table now, say this is what we found. We're never gonna be able to pay this back. So, we can at least settle it now, and this doesn't have to, the can isn't kicked down the road. And it would then free up those RTA funds for something else that the city would want to do instead of just paying interest, and it still would never be the full amount.
I understand what you're saying, but I think that it's irresponsible to say that there was never any intent for this to be paid back. Why would they have done it? So, I mean, the assumption that you make is that an entire city council decided that they were going to lie to the people.
No, not city council. No.
This is exactly how this is playing out, is
Okay.
that an entire city council conspired to lie to the public and say, we're just going to you say this is a loan. Hey, we'll let city councils in the future worry about how it's going to get paid back. But right now, we're just going to do it because we have to get this convention center expansion done. So
I didn't say city council, so I'll clarify the words that you're putting in my mouth. I think urban renewal had the intent of never paying this back. That it was signed, sealed, and delivered by us, not by city council or past city councils. I'm taking responsibility for folks that were well before me and trying to right that wrong that they did. I'm
Yes.
not saying it was city council. I think it was us. That's why it's on the table right now in front of God and everybody. So this is what we saw. This is what we're seeing. We know that we can't pay it back. So we'd like to bring it to the table now to solve it. That's what I'm saying. I'm not blaming past city council. I'm not saying that city council lied to the constituents to get this passed. I think that the past urban renewal did this with the full intent that, yes, I will not be on the board when this has to be paid back. Let's get it done.
got it. Councilor Maestri.
Yes, because that's what I heard, Chris, more so than what President Aliff said, is that Urban Renewal made this pledge to OEDIT in order to get this transaction done. But when you're bringing it back to council now so you can make good on it, what's happening is that we don't have $12 million to buy the garage in order to pay back the half-cent sales tax fund, because that's the way to cure it.
Right? No, and I know you guys don't, and that's,
And so,
would have been
you're putting us in a predicament.
Mr. DeLuca, let her finish.
You're
and-
putting us in a predicament to clear your predicament, but your predicament was made by you, admittedly so. And so
sorry. There's a
you
breakup in
just
between.
admitted that you guys or whoever before you made this deal and wasn't able to keep the deal. And so now you want to bring it to us. We don't have $12 million to buy a garage right now. And the only way that this can be made whole is to reimburse the sales tax fund. So-
Right, or when it matures, the city just gets the convention center. So, I mean, no matter what we do, I don't see the 12 million getting repaid. We can't. We're only gonna be able to afford and pay the interest based on the RTA requirements. So no matter if we do it now or if somebody does it in the future, it's always gonna be an asset exchange. It's never gonna be a cash exchange. That's what so I guess.
Mr. DeLuca?
Yes.
Excuse me, but right now we have a Pope building because someone couldn't fulfill their contract. And we have other things that are just more like weights around our neck and the taxpayers' neck, and the taxpayers are still paying for them. And right now, I think that this council's responsibility is to assure that the sales tax fund gets refunded, because the council at that time made a decision that it should be a loan, put interest on it. So they were fully expecting that to be done. They were being responsible on their part. It's not responsible on our part to accept this deal without, like how Mr. Aliff has said, that we should accept it. And that's, we have to buy the garage in order to reimburse the sales tax fund.
So one thing I would like to point out is the RTA grant is a city grant. So the project itself is the city's. Urban Renewal is the fiduciary arm in this grant. So we were working under an IGA cooperation agreement with the city to enact these projects, to complete these construction that were the eligible projects of the RTA. So this is an us problem, not an you versus Urban Renewal problem. So I think
Well, I
that
guess this is
in cooperation, the city council and Urban Renewal tried to make sure that we did not lose an injection of $35.7 million to this community. And so in collaboration, created this loan, did what happened, whatever the past city council and past urban renewals made decisions on. Now we have to figure out how to move forward in a collaborative way, because this is a city grant, not an urban renewal grant. This is a city grant. So urban renewal is just the fiduciary. So we did issue bonds. We were the only, I believe, I think we were the very first and the only RTA project in the state that was successful in issuing bonds for their project, not just other types of financing, but an actual bond. So part of that was the collaborative effort of city council and urban renewal with this loan, understanding that in the future, if payment was not made, an asset would be given to the city council to satisfy the debt with the half-cent sales tax.
So that's in the contract?
It's satisfied with a deed of trust, yes.
It is secured by a deed of trust, just like all our other PEDCO deals primarily, or the majority of our PEDCO deals, they are secured by deeds of trust. So if it is unable to be paid, then the remedy for the city is to recover the real property asset, which in this case is the convention center, if it's carried to fruition.
And I believe that the deed of trust is actually secured on the full convention center. So you would actually be receiving more asset than the loan paid for.
So I guess we're expecting for you to give legal advice on whether or not that is sufficient in not fulfilling the contract as per the council had entered into the agreement in order to reimburse the sales tax fund.
So this would be the same as any other agreement that we have with anybody that gets money from the half-cent sales tax. If they're unable to pay it, we have a deed of trust typically against a real property asset, and we get that asset. You pointed out, that's how we ended up with real property assets in the half-cent sales tax fund. And so that is how it is secured.
So how many years has this been in effect, this contract?
2017.
Yeah.
So that's 8. That's I'm looking at about 2.6 million, and you said it was how much that we've received? In
1.7 as of the end of last year. There is a current invoice sitting on my desk for, I think it's 112,000, which would be the first interest payment for this year. Now, interest did not start accruing until the proceeds of that loan were drawn down.
Has there been any
and
other interest payments that have not been paid?
no,
we
we
up
are
to
up to
date?
date up to this current, yes. And I believe that your finance department can provide any invoices that you'd like to see, or I can as well.
So
I think that
I think that the loan, because why should we foreclose if we're receiving interest? At least we're receiving something back. You know, I don't know. This is probably going to have to be a later discussion because we don't even have all members of council here tonight.
Counselor Maestri, I think what might be appropriate is if we schedule an executive session to get some more background information and then allow council to give direction for negotiations on this going forward. That may be appropriate if you want to do that.
Counselor Flores?
I've thought about this for a long time, since I've been on urban renewal. Number one, I was not on the council in 2017.
I don't think you were.
I came in, after that decision was made. But from what I know, the council did nothing wrong.
no,
There was no, this all went through all the legal channels and all of that. We just heard from an attorney that really binds us together, urban renewal. You do nothing without our ratification, practically. And something like this reminds me of a marriage, a husband lending his wife, in this case, what, 12.2 million.
14
And
for
then charging his wife interest. And then on top of that, if they get a divorce, they'll both be in the same position they were before the debt. So I really believe that here's another thing is that as a result of whatever that council was thinking, we did get an exhibition hall and we also got the parking structure. As a result of that, it produced what they wanted to produce was economic development. Our sales figures through our convention center, I think will probably, the additional revenue is probably going to be something like 1.3 million for last year after the books are done. So whatever they were thinking back there. But here's the interesting thing. What could we be doing at Pura with 366,000 in interest payment? I mean, there's an amount there that's been taken out of the revenue of Pura to pay this interest, and it's accumulated to, what is it, 1.7? Did you say 1.3?
1.7.
Yeah.
So I think that we need to separate urban renewal from the state sales tax increment funding. Urban renewal only receives that because of the city's grant. We are the fiduciary arm that is part of the agreement with OEDIT. That is why urban renewal receives those dollars versus the city receiving them directly. So urban renewal is tasked per our cooperation agreement with the city and HARP, as well as OEDIT, to manage those funds, certify our costs, and create the eligible projects on the grant that is the RTA. So it's not urban renewal TIF dollars that are funding the interest rate. The reason we're coming to council for this conversation is that urban renewal TIF cannot pay for this loan or the interest. OEDIT agreed that because the city was giving buy-in with this loan, that the RTA state sales tax increment could pay that interest, but not the principal, because you are receiving the assets that the state sales tax increment funded the construction of. So the city's receiving that, the sales tax that hopefully those items generate in the community, PBR, and now Da Vinci Museum, Convention Center, Boathouse, et cetera. So that's why OEDIT, in all the conversations, that's my understanding of OEDIT's point for you can pay the interest, not the principal. So at this time, that's where we are. So separate the TIF dollars from RTA dollars.
Yeah, we just heard that, in most communities in Colorado, that they're either a department of the city or they have their own autonomy and work outside of that. But you only have one reason to exist, and that's to help the city of Pueblo. And so I do think we need to discuss this further, because I would like to see us remove that. It makes no sense for us to be paying ourselves or having a loan to ourselves here.
Mm.
And I don't see it as I don't see you guys as being, Chase Manhattan Bank out of New York, that we've got this obligation. You are
Sure.
part of the city, and we should be looking at how to resolve that. It's just because it's not, I mean, there is no amount of revenue that I see in the foreseeable future that urban renewal can pay this $14 million.
There's not, yes. So, and
Might as
also to
well.
touch on your point, Dennis, $366,000 a year, that would be savings for the RTA funding, could be used for paying off the debt early and having interest savings on the actual bonds themselves, which could then fund the final project, which is the Aquatic Center, which even at this moment, if we paid off the bonds today and saved all the interest with the city, we'd still only have $9 million to go to an aquatic center, which is the final eligible project per this grant, which the city has been completely involved in and has had multiple different types of committees throughout the years on this aquatic center. So to save the money, the eligible items are the boathouse construction and the aquatic center. Those are our final projects. The boathouse is currently under construction, going to be open, I believe, at the end of the year or the first of the year. So we are discussing some of the dollars on hand going to fund that boathouse reimbursements to open up city funding that paid for some of the boathouse construction to be used for other items. So that also helps the city, as well as we have our bonds and the interest on the bonds and this interest. So all of these things are eligible items under the RTA versus TIF.
I think it would be instructive, and this, we probably should end it here, because I really agree with our city attorney that we need to
Absolutely.
dig deeper. But you'll recollect when you go back to OEdit, the expectation, and that's probably why this happened.
Counselor Flores, do you want to make sure your mic is on?
Oh, yeah, sorry. I said the expectation when we got the additional money for the aquatic center was that we would get it in a much bigger lumps. And it turns out that OEdit now is dripping this money to us like one drop at a time, which is like 3%, is it?
3.3%.
And how much is that?
So this past year was $877,000.
Okay.
So yes, the original grant allocation from OEdit was a much larger number. They found that there was an error in the calculation, redid the calculations, and that's when OEdit amended the RTA agreement, the grant agreement with the city. And because we were the fiduciary arm, Urban Renewal, to be 27.7% for the first several years, and then decreasing to 3.3%, which is why the bonds were formatted to kind of upfront a bunch of payments and then have lower principal payments for a period of years, and then have a balloon payment at the end, which is why we pre-funded a reserve and a surplus on those bonds to pay for that balloon.
And then to be clear, it was the state of Colorado that screwed up all of that formula. And
They were the ones that-
their solution was to hurt Pueblo, not take
Well,
responsibility.
I mean, I can't speak to that. Yeah,
But
it was a
they screwed up. big
consultant
time.
on their end that had
Mhm.
had the error and found the error, and then they corrected it. Yes, so I
I just
don't.
wanted to be clear
speak any
because,
others.
at that time, whoever the city council was, they had nothing to do with that error with OEdit, or neither did Urban Renewal.
No, it came through as part of the grant agreement with the city. It wasn't a negotiation point.
Thank you.
Yes.
Counselor Maestri.
So when we get ready to go in, when we decide to go into executive session, one thing that I would like for you to bring forward and check into so that you have it ready is that urban renewal has come in front of us tonight, and they have made statements saying that their authority has made false statements to OEdit. And is there some sort of illegal or transactions when you enter into a contract stating that you're going to pay something, but then they're stating that was never their intent?
So
So I'm not asking you. Thank you. I'm not asking you,
I just want
Karen.
to clarify
I'm-
that
I
the
just-
is
I
between the
wanted to-
city and
I'm
urban.
talking to legal
Poetic.
right over here. So, so I want to know, because I don't want to be complicit. Council doesn't need to be complicit in a transaction, a legal transaction where there was no intent. And so council needs to, that legal knowledge to know how getting them out of this situation can affect council in the future. Thank you.
Counselor Boston.
Thank you, Mr. President. Do we have an estimated date on when that appraisal will come back?
The appraiser was in town almost 30 days ago. I'm still waiting on a response on that timeline, but I can update you as soon as I have that. I will send it to the mayor's office for them to share it with council.
The other thing too, in that appraisal, I'd like to know how much money that parking garage would be able to generate per year if there was charges on it. Thank you. If we were charging people to parking, how much?
So there are lease agreements in that parking agreement.
So
Correct.
I would like to know what that is going to be if we put a meter, pay meter there for people to park, or lease agreements or whatever, because AT&T to say that aren't they closed already?
So there was a lease agreement with AT&T for AT&T's employees to park there.
Mhm.
AT&T is no longer there, but what they're negotiating is a lease with AT&T to put in antennas for them. That's a current there, but they are existing leases on the building, and I can get that information from Urban Renewal. They have that available, so I can get
Yeah,
that.
so let's see what the income would be, and then also if we charge paid parking there.
Yeah, we'd have to look at the number of spaces, but we can give you some sort of projections.
Thank you.
Counselor Boston.
I think based on the math in there with the AT&T not renewing, it would be $59,000 per year, it said. If they don't continue their current agreement, but that doesn't include unleased space.
Well, yeah, that's where we look at return on investment is based off of the income.
I'm just saying the
generated.
current ones, it'll be 59,000 per year.
Also, just to note that the green level of that parking garage is all city parking. So that is currently under your jurisdiction, and I don't believe there are any leases in that space at this time. It is used for, there are some open public spaces as well as police parking, etc. So that's almost, I think, a third, if not a little bit more, of the garage itself.
I just want to clarify a couple things that I heard as we were talking, is that the city attorney said, we typically do a deed of trust, and we do a deed of trust on a piece of property when we do a deal with an economic development prospect, right? But the difference is, if you take that property, you resell that property. And the money then, when that property is resold, goes back into the 50-cent sales tax fund. Then there was a statement that we're just paying ourselves. Well, I don't work for the city. I'm not a city employee. I work for the taxpayers of the city of Pueblo. And I keep going back to that argument that the taxpayers allocated this 50-cent tax money to go into this economic development tax, and they should have every right to expect that if there was a loan, it gets reimbursed. That's all. That's my whole argument. Under this scenario, it's never going to get reimbursed because the city's never going to sell the parking garage. The city's never going to sell the convention center.
We
So-
could.
Well, I guess they could, but I mean, why would they do that? So, you know,
I
how
mean, it
does
would
the,
become a
I
privately.
guess what
owned-
I'd like to see, is just what the repayment plan is through the city to the half-cent sales tax fund. Should they take, should city council say, yeah, okay, this sounds like a great deal. We'll take the parking garage or we'll take the convention center. What is the payback then to the half-cent sales tax fund? Is it based upon the revenue that comes out of those entities? And what's that payback gonna be to the taxpayer? Counselor Meister?
Well, I don't think it should be taken back by the city. I think that urban renewal needs to run the income generation out of there and continue to pay the interest and put it back into the half-cent sales tax fund.
They don't pay the interest out.
We pay the interest with RTA state sales tax
Exactly.
funding. It's completely separate. The garage is free and clear. Those lease payments that are existing in the orange level, which is operated and maintained by urban renewal versus the green spaces. And then now AT&T spaces are available for additional leases. So you could have more leases, more lease potential, as well as the antenna lease, as well as the existing leases and the capacity in the orange level that aren't leased. All of that lease revenue goes into a 60-40 split with the city. And that lease revenue is allocated by agreements with the city to urban renewal's portion of the 60%. And then the green level, which if there were leases in the green level, would go to the city's portion. So all of that's laid out in agreements. And the current annual allocation of that 60-40 split, the city is paying urban renewal $80,000. So this would remove that. Yes, we still have the debt service that is a 60-40 split. Urban renewal would ask the city to collaborate still in that way because this was originally a collaborative deal with a new market tax credit to build this garage. So but the lease revenue would be able to be maintained by the city instead of being paid out to urban renewal on an annual basis.
Good. I'm sure we'll get all that information
Yes,
in writing as we move forward.
and I'll work with Carter.
I appreciate you coming today. Mr. DeLuca, thank you for,
Can I add one more thing, Mr. President? before
Absolutely.
we end? Okay, yeah, so I definitely, I mean, I know that we added something to your plate tonight, so I don't think that the intent of this was to come to you and say another dirty deal, I guess, or whatever you'd want to call it. This is, we found this, what do we do? Well, we got to tell the city what we found and how we can solve it. So, I mean, I definitely think that this was not meant to, I didn't want to give you guys any extra heartburn, but when we found it, it's like, we have to tell somebody. I mean, this can't just continue on. So I think that was us trying to be as transparent as we can be as new members of this board as well. So I just wanted to throw that in there. I mean, I appreciate you guys listening to us. By no means do we have to do anything, because I promise we were just as, I guess, odd when we figured out what was going on. So we definitely wanted to pass on that information in the key of transparency and collaboration with the city. So thank you guys for listening to us for sure. Definitely give everybody something to think about, and definitely appreciate your time this evening.
absolutely.
thank
And I want to thank all of the board members from Pura. I know you work your tail ends off, and all the staff from Pura. I know you work very hard, and this can't be easy conversations for anybody. But I know I'm confident we'll all come to an agreement some way, somehow. Because collaboration now is on our radar, right?
Absolutely.
Absolutely. So if nobody has anything else, we will be gone. We are adjourned.